which is beyond the deadlock, mediation as the primary tool for resolving force majeure disputes in the OIC region. Mediation offers a path to commercial preservation rather than mutual destruction. As the premier international dispute resolution center within the legal ecosystem of the Organization of Islamic Cooperation, the OIC, the OIC Arbitration Center is always proactive in helping member states address complex challenges in both investment and commercial disputes. A core pillar of our mandate is to help boost inter-trade among OIC member countries. To achieve this, we must safeguard and preserve those critical investments by strongly encouraging the amicable settlement of disputes. We stand ready, fully equipped, and deeply committed to helping businesses and investors across our member states mediate and resolve relevant force majeure disputes swiftly. Today, we are privileged to be joined by three exceptional practitioners and one moderator who will guide us through the multifaceted dimensions of this topic. To our panelists, Zachary, Barry, and Tariq, thank you for sharing your invaluable time and expertise with us today. To our participants, thank you for joining us, and I highly encourage you to engage actively with the panel during the Q&A session. There's a Q&A tab down there. Use it, ask questions, and I'm sure our esteemed panelists will respond to your questions. I also want to extend my sincere gratitude to our moderator, Amira, who will be expertly coordinating today's session. Without further ado, I formally open this webinar and yield the floor to Amira to begin the discussion. Thank you.
Thank you, Omar. Good afternoon, everyone. It's a real pleasure to welcome you to today's session on Beyond the Deadlock, mediation as the primary tool for resolving force majeure disputes in the OIC region. Over the past years, and even more so in recent weeks, we have witnessed how geopolitics tensions, economic disruptions, and supply chain shocks can profoundly affect the performance of international contracts. These events bring to the forefront one of the most complex and debated concepts in contract law, force majeure. At its core, force majeure is built on a relatively stable legal foundation. Across legal systems and international instruments, it requires an impediment that is beyond a party's control, unforeseeable at the time of contracting, and impossible to avoid or overcome. But in practice, its application is far from straightforward. Indeed, force majeure operates at the intersection of multiple layers: contractual drafting, domestic law, and transnational principles. Whether a clause is interpreted autonomously or in light of the applicable law can fundamentally change the outcome of a dispute. And recent developments, particularly in sectors as energy, have shown that even when a force majeure is invoked, relief is never automatic. Parties must still comply with strict procedural and substantive requirements, including notification and mitigation. At the same time, we are increasingly seeing situations that do not fit neatly within the traditional framework of impossibility. Many disputes arise in a gray zone, where performance is not impossible, but significantly more difficult or commercially disrupted. This is where concepts such as hardship, renegotiation, and ultimately dispute resolution mechanisms become critical. This brings us to the central theme of today's discussion: how to move beyond legal deadlock. While arbitration provides authoritative answers, it may not always offer commercially workable solutions, especially in ongoing business transactions and relationships. Mediation, on the other hand, offers a more flexible and pragmatic approach, allowing parties to rebalance their obligations and preserve long-term cooperation. Today's panel will explore precisely this transition from legal principles to practical solutions, starting with the legal foundations of force majeure before moving into how mediation and other EDR mechanisms can effectively address these disputes in the current regional context. Before we begin, allow me to briefly introduce our distinguished panelists. Dr. Zachary Callow is a professor of law at Touro University in New York and an internationally recognized expert in comparative law and dispute resolution with extensive experience in the Gulf region, including at Hamad bin Khalifa University in Doha. He is also the author of more than 80 books and articles and is also of counsel with Calibian Haggerty in Abu Dhabi and a founding partner and mediator at Gulf Mediation. The Honorable Barry Lyon is an internationally recognized arbitrator and mediator, affiliated with 33 Bedford Row Chambers in London, arbitration place in Canada, and Caribbean arbitrators. He is the former presiding judge of the BVI Commercial Court and bringing a unique perspective from both the bench and international arbitration practice. Dr. Tariq Mahmoud is a litigation barrister and international arbitrator with multi-jurisdiction experience and a visiting professor at Durham University and the University of Kiel. He has served on the Bar Representation Committee of Lincoln's Inn and the Bar Council of England and Wales and speaks and publishes regularly on international arbitration and mediation. So to begin, I would like to focus on the legal foundation of force majeure and how these principles are being applied in practice, particularly in light of recent developments. Zachary, if I may start with you from a regional and comparative perspective, how do Gulf civil codes approach force majeure and how have those doctrines functioned during previous crises, such as the Qatar blockade and COVID-19?
You're muted, Zachary.
Zachary?
There we go. Let's try that again. Um, Good day, wherever you are in the world. Good morning, good evening. First of all, just a word of thanks to Dr. Umar and Dr. Amira for the kind invitation and the kind introduction to participate in this conversation. So I think we're going to ultimately move towards the question of how mediation fits into this, but we'll begin by sketching out some of the legal framework and legal application, and I'll do so by offering a sketch of the legal background in the Gulf region and how we've seen the application of force majeure and related doctrines in recent years. It can be broadly said that the Gulf civil codes adopt an orthodox civil law framework for addressing events that might interfere with contractual performance. You see a distinction between the doctrine of force majeure, which would have the effect of extinguishing contractual obligations under conditions of impossibility, and the doctrine of hardship, which interestingly permits judicial recalibration where performance remains possible, but where it might be excessively onerous. So just by way of illustration, in Qatar's civil code, and you see this replicated throughout the region, but Qatar's civil code in Article 188 would be the force majeure provision. And it provides, among other things, that where such impossibility is partial. I'm sorry, let me actually read from the sentence prior. In contracts binding both parties, where performance of an obligation by one party is extinguished by reason of impossibility of performance due to force majeure beyond the control of the obligor, such obligation and correlative obligations shall also be extinguished. Right? So we have a very classic enunciation of the doctrine of force majeure. Then you can also read this in parallel with Article 171, which is the hardship provision. And this provides that, quoting here from 171, a contract duly and properly concluded between the parties must be kept, and non-fulfillment of the respective obligations is a breach of that contract. Where, however, as a result of exceptional and unforeseeable events, the fulfillment of that contractual obligation, though not impossible, becomes extremely onerous in such a way as to threaten the obligor with exorbitant loss, the judge may, after taking into consideration the interests of both parties, reduce the excessive obligation to a reasonable level. Okay? So these are going to be the twin legal provisions that are primarily relevant to the kinds of issues we're discussing today. And this dual structure again is replicated throughout the Gulf region. You can look at the Civil Code of the UAE, Articles 273 and 249, and find very similar language to the same effect. Saudi Arabia is a bit different from these other civilian codes. Its law is an amalgamation of Islamic jurisprudence, statutory law, and judicial discretion, but it did receive a significant clarification and concretization in the 2023 Civil Transactions Act, where you can find language that, although not duplicative of, at least captures the essence of what we saw in the Qatar Code regarding force majeure. I believe my colleagues are going to speak in detail about the common law and points of differentiation, so I won't diverge down that direction. But it is important to note that the Gulf codes are civilian law based, French law primarily refracted through Egypt, and that provides the judicial framework. And the main distinction, and this is all that I'll flag on this point, but the main distinction to note, at least at a broad level, between the civilian approach and the common law approach is that common law systems don't have a statutory definition of force majeure. The work is primarily done through the cultivation of judicial doctrines by courts. The one notable exception might be the Uniform Commercial Code in the United States, which at the state level does some work. But by and large, in certainly US law and English law, force majeure is not a freestanding doctrine, but is primarily treated as a creation of contract. And I think it's fair to say that by and large, at the level of practical implications, there's significant convergence between the civilian and the common law approach. But of course, there are some important distinctions that I'm sure we will address. And just to flag another issue that I think we ought to keep in mind, that although we have this legal architecture in place in domestic law in the Gulf, many of the contracts are going to potentially be governed by foreign law, English law being a particularly common choice. And so we have to confront the intersection between foreign law, domestic law, all being adjudicated in a regional court. One other point that I think it's just by way of background that it's important to emphasize is that even though we have this statutory framework, the most important thing to look at is the contract. Right? That the focus of the analysis is going to begin with the contractual language and the contractual provisions and how the court might approach that. So generally, courts will be, including in the Gulf, deferential to the stated intentions of the parties insofar as they have addressed force majeure in the contract. And so the law as a freestanding provision would only be applicable in the full sense in the absence of a contractual provision. Assuming there is some kind of contractual language addressing force majeure, then we have to look to the interaction between the contract and the statute, with the statute filling in gaps and providing an interpretive context. But really where you want to begin and where a lot of the potential challenges are going to be for clients is in looking at the drafting of the contract and the language as it pertains to the facts on the ground. And this is where drafting is really, really crucial. I'm sure my colleagues will speak in more detail about the application of these rules in different contexts, but one principle that is in various ways applied more or less universally is the notion of strict impossibility. So the fact that a set of circumstances makes fulfillment of a contractual requirement more difficult or more expensive will generally not be a basis for claiming force majeure. So, for instance, if a contract might specifically denominate that goods shall be delivered via the Strait of Hormuz, then we might have a much more clear case than if the language was much more general and where the goods could be provided or the services be provided by some other means. Now, in terms of application, just to speak in kind of concluding to the application in the Gulf region. These as civilian systems, they are not precedential systems, so case law in and of itself is not going to be determinative. But we also have very little reported case law. So we don't have a whole lot of raw material to work with either in the domestic courts or the various international or commercial courts. But I think we can nevertheless piece together a broad outline of how courts have and might well approach this question moving forward. And I'll just say a few things along those lines. As I mentioned above, this notion of strict or objective impossibility tends to be an important principle. So again, claiming increased cost, increased difficulty, diminished profitability are not in and of themselves going to be a strong basis for excuse of the contract. And you could see this, for instance, in the blockade of Qatar by neighboring countries in 2017. So the closure of the land border with Saudi, the closure of airspace, which increased transport costs, disrupted supply chains. These events, in and of themselves, insofar as they, in most cases, would not have rendered a service impossible, but merely more difficult and more expensive, would not likely have provided a sound basis for a successful claim of force majeure under the text of Article 188. Another provision that is well established. Oh, sorry.
No, just if I might ask you
Yeah.
to put up in 1 minute for.
Yes, absolutely. Yep, I'm reaching the end here. Just a couple of other points to mention. The event needs to be external, that is not caused by a party. And another point, and I think this is quite relevant to the current conflict, is the principle of unforeseeability. And one might posit that a war is always in some sense foreseeable, but that begs a lot of different second order questions. What kind of war? Beginning at what time, right? If one were to posit that this war was foreseeable, when? 1 year ago, 6 months ago, during the summertime, when Iran attacked the US military base in Qatar, 2 months ago, when US military assets were moved to the region. So you can see the intrinsic density of trying to analyze these provisions, which are by their nature extremely and necessarily fact intensive. And I think that kind of difficulty and, if I may, kind of uncertainty that is baked into this legal doctrine will eventually create the bridge that I think we'll explore in the second half regarding why mediation can be an effective approach.
Thank you, Zachary. This was very insightful. Barry, turning to you from your experience on the bench and in arbitral practice, building on Zachary's overview of civil law jurisdiction, how does force majeure operate in common law jurisdiction? And are there other common law concepts that may become relevant where contractual performance is disrupted?
Let me take the first part first, the force majeure. And I can't help but note Zachary told us when we were beginning that he's in Vienna where the Bismuth is taking place. And coincidentally, as it turns out, the Bismuth problem this year, which involves students from around the world, has an issue of force majeure. So maybe it was foreseeable to the people who wrote the problem, but more likely it was coincidence. So force majeure is very much on people's minds and tongues these days. The common law situation, if you stand back from it, is not all that different than Zachary described. So there's a four-part test for force majeure. If you break it down, and it's really there's a fifth part that I'll add, that the event occurred. So there's the force majeure event, or the event that's alleged to give rise to force majeure, that the party was prevented, hindered, or delayed from performing, that non-performance was due to circumstances beyond its control, and there was no reasonable steps available to avoid or mitigate the event. The fifth test is timely notice, timely invocation of the clause, and that's usually provided. So the starting point in the common law world is the contract. And of course, the parties are free to write the clause as they see fit when they're creating the contract. And one of the things we'll come to talk about is where contract drafting is going and where it should be going. But it's up to the parties to define their respective areas of risk in the contract. And one party may have expressly or impliedly assumed the risk of a fundamental change in circumstance, or on the contrary, certain risks have been expressly or impliedly excluded. It's all a matter of contract interpretation. The foreseeability is an interesting concept, and I'll come to talk about something out of the legal world, but from a business article that I happened to come across the other day that talks about things that are generally thought or talked about as having been unforeseeable, but in fact were foreseeable according to the author. And then that comes back to what Zachary was saying about whether the current circumstances were foreseeable and when and how. The clauses commonly define force majeure as an unforeseen event beyond the party's reasonable control that impedes performance. And when it comes to contract drafting, the clauses sometimes include illustrative lists of events, common ones being warfare and hostilities. And as the world evolves, those events become, perhaps with hindsight, added to the contract. So following the global pandemic, all of a sudden, global pandemics became more foreseeable than they might have been before. And of course, there were issues as to whether the pandemic was a first ever event or whether, in fact, it was foreseeable because of things that occurred in the past, either long times ago or the SARS of a shorter time earlier. So foreseeability may be a key point in any dispute. And because it's amorphous, it's going to be one of the reasons why we're going to talk about the difficulty of establishing each of these factors and where mediation fits into it. Now, each common law jurisdiction may have its own tweaks on force majeure. So one does need to look at not just whether it's common law, but at the governing law of the contract. It is contractual in common law jurisdictions. And then there's the second question, the factual question: is there a causal link between the event and the alleged failure to be able to perform? The required threshold for this link will vary based on the wording of the contract. Some contracts may say that it needs to be rendered impossible, while the contract could accept a lower threshold where the performance is merely hindered or delayed. It's up to the parties to
So,
decide how they want their contract to be worded.
Barry, staying with you on this, from your triple perspective as a former arbitration and litigation counsel and the former commercial court judges, and now an arbitrator and mediator, are you seeing any changes in the way force majeure clauses are being drafted in commercial contracts? And what trends do you see emerging in cases in which force majeure is issued?
I think the trends, as I was just mentioning, uh, tend to be that parties learn from experience and are trying to to avoid disputes. So make the clauses clearer is one thing, and secondly, broader. And it's a matter of negotiation, but to cover situations which weren't considered foreseeable at one time and now more arguably are foreseeable. So like any dispute avoidance technique in contract drafting, the clearer that you can be in the contract, the better. But of course, the difficulty in this area of contract drafting is that you're trying to be clear on something that conceptually is unclear or unforeseen. So you're trying to you talk about hostilities or war. Is that sufficient in your contract, or do you want to go much further? And of course, it cuts two ways, because by being more specific, it may be argued that you've limited the categories more than you wish to. So it takes thoughtful contract drafting. And like most areas of contract drafting, the last thing that the party should be doing is pulling out a precedent, which likely involve different circumstances, even if it's in the same industry, and sticking it in the clause without taking the time to think through and talk through what could give rise to the invocation of the force majeure clause. And I'll talk more of this when we come to mediation, but thinking about the circumstances of the parties and what they could provide contractually in the event of circumstances arising that are different than anticipated, but may or may not be legally in the jurisdiction a force majeure. And price adjustments, contractual performance adjustments that are negotiated or, dare I say, mediated, may provide better solutions for the parties, both in terms of the immediate dispute that could arise and their longer term relationship. And then that will take us to mediation. I was just going to add probably the most important aspect of all of this is being thoughtful and putting in the time and involving people who are informed in the client company to be thinking through what are the not just the possibilities, but the unforeseen possibilities, if I can put it that way.
So, do you see parties making mistakes or not being as effective as they could be when invoking force majeure in arbitration or litigation? What could they be doing more effectively?
I think the main thing they can be doing more effectively is the kinds of things I was just talking about, to move to tailored force majeure provisions and to think more broadly. There's a few interesting quotes that I came across, which if I can put my finger on them here, I think they're applicable in this kind of situation. And one is the famous or infamous quote. Sorry, one more second. I think I'll hand on it. The quote from U.S. Secretary of Defense Donald Rumsfeld when he was back in 2002, and that there are unknown unknowns. If you recall, he said there are no unknowns. There are things that we know. We also know there are known unknowns. That is to say, we know there are some things we do not know. But there are also unknown unknowns, the ones that we don't know, we don't know. If one looks throughout the history of our country and other free countries, it is the latter category that tends to be the difficult ones. Well, that's the situation that the contract drafter is in, or the parties working with the contract drafter to try to cover off in the drafting of the force majeure clause or other contractual remedies, the kinds of situations that by definition are unforeseen. It's the need to expect the unexpected. So I think that, to return to your question specifically, are things that parties can and should be doing to improve their position when an alleged force majeure event arises, and importantly, to avoid disputes, whether in court or in arbitration.
Thank you so much. Very, very interesting. I will keep us moving, but very happy to take a brief reaction, very brief, if anyone wishes to add anything.
I only want to add, and I kid you not, that as I was jotting down some notes in preparation for today, I wrote down the quote "known unknowns," which is a very useful quotation from our previous Secretary of, well, then Defense, now War. I put it down in connection with the idea that this area of law, even if the text of a law is clear, even if the language in a contract is on its face clear, that there's just a lot of inbuilt uncertainty and risk in applying these principles to the facts. And part of what I think we need to talk about today is how do you manage that risk and uncertainty, or if you will, the known unknowns.
Very interesting. Yes, of course. Thank you again. And Tariq, from a more contractual and a drafting perspective, what are the key clauses or mechanisms that parties should include today to better manage force majeure risks?
First of all, I would like to thank Omar from the Organization of Islamic Cooperation for inviting me as a guest speaker on this webinar. Thank you also to yourself, Amira, for the kind introduction. I think moving on from what Barry had said, the real crux of the issue is the clauses themselves. And I think it's pivotal that at the outset of when the contract is being finalized, that we have more bespoke clauses. What I've seen in the past is that you see generic. I'm not saying all lawyers are like this. You have very good lawyers and very good counsel who prepare very thorough clauses and review clauses. But what I would say is that it's important that we have bespoke clauses, that there is greater attention played on focusing on the key issues, especially in the force majeure context. And what I would say is, firstly, my advice would be that we need to list the threats explicitly. So it needs to be explicit. And I think we'll come on to this later on, but it's important that when it comes to the interpretation of the contract, which the judge will consider, that if the clauses are black and white, the judge can take that into account when addressing the issues and the relevant four-stage or five-stage test, which Barry outlined. So I would say threats need to be explicit. They need to include words such as armed conflict, war, terrorism, hostilities, government-imposed restrictions, sanctions, blockades, closure of shipping routes, ports, especially the position that we're in with the Strait of Hormuz. Now, what I would also say is that especially the knowns and the unknowns from the subcontinent context, what I would say is that Pakistan and India have had 3 wars. So in 65, in the 70s, and very recently. So there's a pattern where every so often, every 20 years, the arch nuclear rivals have a war, and the lawyers from those from the specific continent have seen those issues become relevant in the context of trade, and therefore have had the opportunity to reflect and consider and address those issues a bit more, I would say, explicitly, rather than having wordings within the contract which may be more generic or broad. So secondly, I would say is that we need to define the threshold. So the issue of hindrance or frustration or impossibility, it needs to be set out. Again, it needs to be very clear. We also need to address the known conflict risks. So the issue of foreseeability, which is part of the four-stage test, there needs to be within the contract specific clause that addresses the state, that the clause covers issues such as escalation, the knock-on effects of known events such as the current war and instability in the Middle East. So as long as we have explicitly set out the known conflicts within the specific force majeure clause, it becomes helpful when parties are trying to resolve the dispute, or if the matter can't be resolved between the parties through, say, mediation, then ultimately the judiciary can have a very clear position. And I think we'll talk more about the approach that the English judiciary take in terms of whether it's a narrow interpretation or a wider interpretation. But certainly, I would say, in terms of my tips and advice, that we also need to align the contracting chains. That's also, so back-to-back terms need to be set out within the clause. We also need to address the issue of mitigation costs, especially if it requires rerouting with the current scenario that we have in the Middle East. Some clauses should specify the costs above a certain threshold or potential. So in certain cases, if there's a cost threshold that's beyond a certain amount, will those costs be shared? It all needs to be set out in the force majeure clause. And I think the key message to those individuals that are drafting these contracts is clarity, clarity, clarity. You need to be explicit. You need to address the causal link. So to qualify, you need to quantify the force majeure event in the sense that it must be directly the cause the parties' inability to perform the contractual obligation.
So to
Now,
be more
the,
clear, in general, this is the key for the contractual drafting. And staying with you on this, how do you see the interaction between force majeure and hardship evolving in international contracts, particularly in regions where courts tend to favor contractual stability? I have also
I
another
think
question for you if we want just to maintain the time allocated. Um, I'd like to take the floor to answer this question, and I would proceed later.
okay, thank you. Now, in terms of the common law approach and in terms of the English judiciary, the English jurisdiction take favor in terms of contractual stability. And the general approach from the English courts is that there's a narrow interpretation of majeure in the United Kingdom. There's a recognition, there's an express recognition of expressed hardship. But the point of what needs to be clear is that there's a general shift from a judicial intervention towards parties and directing their solutions between themselves rather than the court being involved. So the approach now is a combination of clauses to address the issue of hardship and force majeure. Uh, the, in the main, I would say that the courts remain reluctant to rewrite contracts, but are willing to give effect to express clauses. So well-drafted hardship and renegotiation mechanisms that formalize the management of economic risk, as long as they are clear, then clearly the interplay between them would be that hardship is will be considered, but it needs to be expressly formulated. And I think what we saw with the COVID pandemic, the doctrine of frustration, which is again a standalone legal concept, unlike force majeure, but it became relevant in the context of potential claims that were being brought. So there is an interplay, I would say, between the interaction between hardship and force majeure.
Thank you, Tariq. That brings us nicely to the practical implications of these issues, and it brings us to the second part of our discussion, how to move beyond deadlock in practice, and in particular, the role of mediation and other ADR mechanisms. So, Zachary, building on your earlier remarks, what factors, whether legal, institutional, or culture, in the Gulf region inform how mediation might be used to address force majeure disputes arising from the current crisis?
I keep doing this. I want to say this. The star of this webinar so far has been your delightfully mischievous cat who makes occasional appearances. He should have his own screen here. Yeah. So uh, let me offer just some thoughts about the range of dynamics that I think inform an overall assessment of the situation in the Gulf. And none of these are going to be unique as such to the Gulf region, but I do think, viewed especially in their totality, they create an overall context in which we can start to imagine where and how mediation can fit in and also why it might be particularly effective. Um, I want to do this by just offering a couple of thoughts on the legal dimension, the cultural dimension, the commercial dimension, and then also reference what has happened in the region by way of developing infrastructure for mediation overall. In terms of law, Yeah, I think it's important to again just emphasize the points that several of us have made and that I referenced in my opening remarks about the risk and uncertainty that is baked into a claim for force majeure. And that might well be amplified when you're talking about the legal risks of operating in a foreign court, perhaps applying foreign law in a foreign court, and also the extent to which one has confidence in these institutions. And if we're dealing with courts in the Gulf, we are talking about, at least in terms of the domestic regime, civilian courts in which there is limited case law and interpretive variability. We're dealing with potentials of asymmetry when engaged, perhaps with a domestic entity in a, sorry, but engaging a domestic entity if you are a foreign company. So I think there are a lot of kind of just general legal considerations that we've discussed about that really bear on the assessment of how mediation can fit into this. And as we've seen, I mean, force majeure generally, I mean, there are some alternatives for amending contracts, but by and large, the nature of force majeure is to generate a binary outcome, to either extinguish an obligation or to leave it in place. And one could well get a favorable legal result, but a result which is not commercially what is needed. I mean, a legal claim for force majeure is, at least to a large extent, a retrospective action that can also be limited in its scope and effect. And companies need to be making forward-looking decisions under these conditions. And so into that matrix, you can begin to see how mediation, which is by its nature forward-looking and adaptive, can allow parties to construct solutions that reflect the evolving nature of the disruption. And also, just to mention, I think another important point is that mediation, of course, can operate in parallel with an assertion of legal rights. So it's not an either or. One can continue to assert a legal claim while nevertheless seeking a consensual remedy. Just briefly on the cultural dimension, sort of dealing here, of course, in broad sweeps, but I think it is important to note how commercial relationships in the region are often long-term, they are relational, they are embedded in networks of trust and reputation. And while one might posit this in all manner of contexts, it does have particular weight and relevance in the region. And so asserting a legal claim, whatever its legal merits might be, can be viewed as a breakdown of that trust or that relationship, which can have long-term implications for ongoing commercial relationships. And there is, and we can talk about this more when we get to the maturation of mediation in the region, but there's a deeply embedded cultural openness to resolving disputes through negotiation, through informal mechanisms. And so this is something that can be intrinsically receptive. On the commercial front, let me just flag a few things that I think are very relevant to our discussion today. We're dealing with regions in which the state often has an outsized role in commercial transactions. Right? So many of the most significant contracts are going to be in sectors such as construction, energy, infrastructure, where one of the parties is going to be an entity that is controlled by or fully or in part by the state. And these actors are not necessarily operating as purely profit maximizing entities, right? There are different motivations. They are operating, at least to some extent, under the umbrella of national development strategies. This gives rise to potential power dynamics if we're talking about litigation, especially in a domestic court. These are relationships by that very nature are likely to be potentially long-term, right? So again, the assertion of legal rights, whether it be through litigation or arbitration, may generate an outcome that is technically correct and legally advantageous in a discrete way, but undesirable in the long term. And of course, mediation, for all the reasons we can identify, offers a mechanism for pursuing commercially sensible adjustments. We're dealing with disputes that very likely could involve long-term, capital-intensive projects, sectors again, such as construction, infrastructure, energy. Right? These are interdependent, long-term relationships, and often involving multiple parties and joint ventures. And so, an interruption is not something that can simply be easily carved out of a long-term, complex commercial relationship. The last thing I'll mention along these lines is where mediation is in the region. So I think we can see why mediation can fill a lot of the gaps, but we also have resources for doing this. The past 5 years, one could push it back to the past decade, there has been a remarkable flourishing of, if you will, a mediation culture in the region. This has involved laws. So Bahrain, Qatar, UAE in recent years have all issued new mediation laws. Saudi Arabia has a draft law, new institutional rules. DIAC in Dubai, the Qatar International Center for Dispute Resolution have issued mediation rules. Saudi Arabia, Qatar, the UAE have all signed the Singapore Convention
Of course,
on
the
mediation.
OIC Arbitration Center
And the
has
OIC
also
Arbitration
mediation.
Center. Exactly, right? And I view what you are doing as part of this maturing ecosystem, if you will. And while 10 years ago, almost all of the conversation was about arbitration, that's what people talked about. And now mediation is being developed both from the top down in the form of law and institutions, but also from the bottom up in terms of what commercial parties understand and expect as best practices. And so this would be a very different conversation for us to have had in 2017 around the blockade. It would have been a very different environment and a very almost abrupt proposal to say, have you considered mediation? But much has changed. And so all of these dynamics I've identified, which are deeply rooted, the cultural, the commercial, the legal, now are operating in an environment that is fundamentally different. And I would propose highly conducive for thinking in creative ways about how mediation can insert itself into what are likely to be a series of disputes.
Thank you so much, Zachary. Perhaps others may also wish to briefly, but very briefly, react before giving the floor to Barry. Okay, so Barry, from a practical dispute resolution standpoint, in your experience, at what point should parties facing a force majeure situation begin to consider mediation? And also, may I give you also another question so that I give you the floor completely? As a mediator, what key consideration should parties keep in mind when navigating a force majeure context? Are there any practical levers or if not magic bullets that can help unlock these situations?
Well, let me start by saying that the point at which they should be considering mediation is when they're drafting their contract. And I say that because not just because you could have a dispute resolution provision in the contract that's often called a step clause, where mediation is built into the dispute resolution processes. So the typical step clause starts with direct negotiation and then mediation and then an adjudicative form of dispute resolution, whether in arbitration or the courts. So that's one time they should be considering it. And then I'll come back to traditional mediation, but I think the second thing at the time, or the reason they should be considering at that stage, is because what's becoming a hot topic in the mediation world is dispute avoidance. and that is for the parties to involve a mediator, or sometimes it's a three-person mediation body at right from the outset of certain kinds of contracts, particularly contracts that have a longer life to them. Project, I mean, it started in the construction area, but infrastructure, I would say there's all kinds of supply contracts, technology development contracts, pharmaceutical development contracts, where the parties are going to be living together for quite a while. And disputes can arise. And so what the concept would be to deal with disputes, that all kinds of disputes that start to appear on the horizon, and nip them in the bud. But dealing with our topic, by definition, force majeure situations are not ones that you see developing as readily. But on the other hand, building into the process where the parties and with the assistance, if it can justify the cost of a neutral third party, are watching out for these situations, these disruptive situations, whether they may constitute force majeure or just may upset the commercial relationship, and dealing with them. Which may involve adjustments to the contract itself, but preserving what is important for the parties to preserve, the relationship, the bigger project. And so that's the time when I think parties should be thinking about mediation and what I'll call dispute avoidance through the use of a mediator. Secondly, the kinds of situations that we're talking about are almost always more suited to a consensual resolution. Why is that? Because they're very uncertain. Just from the discussions we've had on this webinar, there are going to be, it's very much a question of how are things perceived, in terms of foreseeability and the measures that could be taken to deal with what occurs. There's some areas of the law where there's great imprecision in two ways: how a decider, a arbitral tribunal or a court, will view the situation. There's a lot of wiggle room, and that will be affected by all kinds of things, including their perception of the equities and the parties. So, trademark law, for example, to my mind, is always an area where, is this confusing with that? And it's very much a question of perception. It's the beauty is in the eye of the beholder. And I think that applies in force majeure situations, because you can look at a situation and say, was that foreseen? And all three of us have talked about situations like that. So if you're going to be taking a dispute to be adjudicated, and you've got that kind of uncertainty about the process, how it could turn out, and then of course you've got the usual uncertainties around the evidence and how are you going to prove these things. Mediation provides a wonderful way for the parties to deal with the fundamental problem and to try to find a solution to the problem that, in the circumstances, may not leave either party as happy as they would have been if the force majeure incident hadn't occurred. But on the other hand, will leave both of them in a reasonable position, and will have other benefits, particularly where there's relationships, will preserve relationships. So at some point, the particular contract problem is going to be behind them. And will they be doing business again? And will they be carrying on with the project? So for all of those reasons, I think there is an important reasons for the parties to be looking at mediation, understanding mediation, and if it's not built into their contract, adopting it at the earliest stages of an emerging force majeure situation arising, and curtailing it. It takes a little courage to when you. I think it was Zachary who talked about the incidents in the past preceding the current hostilities in the region, and maybe at that point the parties should say the contract is working well, but maybe they should say, look, we can see a problem emerging. I know we've got a contract, but should we be renegotiating a way to deal with what now seems more prominent on the horizon?
That's a very interesting way at looking to things, actually. So we go back always to the drafting of contracts. So that's the magic bullet at the end. So Tariq, from a forward-looking and drafting perspective, do you think mediation should be embedded directly into force majeure clauses? And if so, how do you see this?
I definitely agree that mediation should be embedded within the force majeure clause, or there should be a specific clause that specifically addresses that if an issue arises and if it's one of force majeure, that it can be dealt with by way of mediation. And I reinforce what Professor Zachary has said, that there tends to be now, especially within the GCC region, within the subcontinent, a better understanding of mediation. There's been a lot of work that's been carried out by the Chartered Institute of Arbitrators in educating, training mediators around the world. And then you have the Singapore Convention that's been adopted by a number of countries within that specific region. So I think, yes, you can have mediation embedded within the force majeure or within the contract. Again, it's a point that needs to be addressed by counsel, general counsel, or by corporate lawyers at the outset. But there's absolutely no harm in terms of what Barry has said, that there's many cases where individuals may not have a specific clause that addresses issues in relation to matters being resolved by way of mediation. And one can have a bespoke agreement between the parties to say, listen, we're in a dispute, we need to resolve this. And then there's the issue of confidentiality. In the same way you have confidentiality within the arbitration context, you have confidentiality within the mediation context. So if a matter is resolved by way of mediation, and a mediation, a resolution and an order is drafted, it has the approval and blessing of the court and can be approved, but remain confidential rather than being in the open. And sometimes, especially when it comes to issues of confidence, especially in the infrastructure construction arena, there are a lot of companies who want the matter to remain confidential. They don't want to make this a public issue that's going to be wrangled through the court. So I think I would say that mediation is something that should be a way of potentially resolving disputes early on. And then there's a lot of education that needs to be given, but what I would say is that there's a lot of people, lawyers, professionals, business people, who are aware that if a matter goes to arbitration or if a matter goes to litigation, they could end up being very costly to them. And they may want to resolve the matter, they may want to preserve the relationships. There's an element of speed and flexibility within mediation. And I think, therefore, it's pivotal that those individuals who are drafting contracts consider this at the outset in terms of when they are contemplating dealing with the issue of force majeure clauses.
And in the OIC context, do you see specific legal or cultural factors that make mediation particularly effective in resolving these disputes?
Yes, wholly. I would say that within the GCC region, what we tend to see is that the cultural and religious elements are entwined between there being an understanding of compromise, the Arabic word sulah. And I think that's very common in terms of the Middle East region, but also in a lot of Muslim countries where companies that have an ethos of wanting to resolve disputes, or individuals that want to resolve disputes, feel specifically guided by the point that Professor Zachary was making about Saudi Arabia having an element of the Sharia principles being applied within the issues when it comes to rather than having simple articles constituting specifically addressing issues of, say, force majeure. There's an element of Sharia. So what I say is that there's an element within the cultural and Islamic perspective of people valuing Islam to resolve disputes amicably. And there's a tradition of going back generations, hundreds of years, whether it's in the subcontinent or whether it's in the Middle East. There was no traditional court structure, so people relied upon traditional elders or people that they respected as mediators that were respected, and they were those individuals that were able to resolve complex disputes relating to territorial disputes, to maritime disputes. And I would say that there's an element of trust and credibility that if a matter is being resolved with a specific ethos or a cultural context, that aligns with their religious belief.
That's true. In many Islamic legal traditions, mediation and amicable settlement are not only encouraged but deeply rooted, actually. The concept of sulh, which refers to reconciliation, has long been recognized as a preferred way of resolving disputes. Rather than focusing on rights and liabilities, the emphasis is often placed on restoring relationships and achieving a fair and balanced outcome between the parties. So before we move to the conclusion, I don't know if anyone has something to add before I would open the floor to questions from the audience.
If you don't mind, maybe I'll just make a quick intervention that could also begin our engagement with the question that James McPherson posted on the board. And I believe James was asking about what organizations like the OIC AC can do to contribute in a concrete way to what we're talking about. And the point I wanted to make was kind of twofold, that I think it's helpful to think about this topic both with regards to immediate needs and concerns and challenges, and then what are the long-term implications? And Barry was giving us some ideas about maybe this will change how parties contract. I mean, it was uncommon before COVID for there to be references to pandemics or endemics in the string of qualifying events in a force majeure clause. and now they're going to be much more common. And people have short memories, but one might hope that these disruptions, certainly in the region, might change the ways that parties behave, but also contract. And I thought Barry's remarks about step clauses and dispute avoidance. I mean, these are all techniques that are in the toolbox that people are talking about, and the challenge is to how to get those into concrete expression. I mean, the ICC recently issued guidelines on mediation and force majeure. So the resources are out there. But in terms of the present situation, there's a lot of experience in the Gulf, at least in some limited ways, in how to respond to these situations. In the UAE during COVID, there were some sort of guidelines that were issued regarding commercial leases that, at least in a certain sense, nudged parties towards some kind of consensual approach to dealing with the impact of government regulations. Qatar addressed this during the pandemic by creating a fund that could provide bailouts to certain affected companies, and that has an effect on mediation. By shifting costs to the public, it arguably can free parties to negotiate more fluently. But the idea I wanted to just put on the floor in regards to James' question and Dr. Umar's mentioning of the OICAC earlier, right, is that there might also be a role for institutions. The Singapore International Mediation and Arbitration Center during COVID set up a specific set of institutional protocols for dealing with COVID-related force majeure claims, recognizing the need to deal with them expeditiously, recognizing the need to provide an attractive and accessible forum for dealing with these issues with appropriate guidelines that could facilitate the process. If we're talking about the Gulf region, insofar as many of these disputes might be sectoral in their focus, having experts with a background in engineering, in project financing, in energy, who can provide this service. So I think there is a bottom-up role for institutions, and we've talked about the interesting flourishing of institutions in the region. So maybe it's time for a working group at the OICAC.
There's one other question, Amira, there's one other question in the chat which I could address.
There are actually a few questions, and we would be very happy to take your question and continue the discussion with our panelists. So the first question is, how can and will the OIC lawyers, parties, and neutrals best approach and deliver on the promise of commercial mediation as it relates to the context where force majeure may play a considerable part? And to what extent do neutral and OIC member states and their courts have a facilitative, constructive role to play?
I think that's, Zachary, is that the question James's question that you were?
Yeah, exactly. Yeah.
That's the one.
Yeah.
Okay. Oh, well, yeah. And there is another one on the contract between Qatar company and Indian company is long-term contract for 5 years. It did not have foreseeable incidents, which today we are witnessing. There was no mediation clause in the contract. How to go ahead in such cases?
Well, I'm happy to say a few words about that to start. I mean, it's quite, and that's Kazi's question. There's most contracts don't provide for mediation, and I think it's incumbent on at least one of the parties or the parties' counsel to charge ahead and propose mediation. And that can be done at any stage. It can be done once the dispute is in arbitration or before a court, but it can be done in advance, even without a contractual provision. And the common concern is, well, is that showing, just like approaching somebody to negotiate, is that showing a sign of weakness? And some people might say it is. I think the better view is that no, it's not. You can have a strong case, but still appreciate that you're better off and the other party's better off by trying to resolve it. So in the case that the hypothetical of two companies with a long-term contract and incidents occurring, no mediation clause, one of the two companies should approach the other. There are some institutions that arbitral institutions where they will, on their own initiative, I believe in the AAA ICDR has that provision, can inquire of the parties whether they want mediation assistance. I don't know if the OIC AC does that, but I was once approached by somebody and nothing came of it, but her objective was to hire me to approach the other side, not as her legal counsel, but as a mediator, simply to try to convince the other side to mediate. Nothing came of that idea. If you read some of the literature in negotiation, the Harvard negotiation project, and Professor Roger Fisher used to do that. They used to find disputes that they thought should be resolved and just become an officious intermediary, go out and contact the parties and try to get them into discussions. And they tried it in the Middle East. They tried it in South Africa. They tried it in Latin America, and some of them led to negotiations. Some they did get themselves quite involved in the end of apartheid in South Africa. So there's lots of ways to tackle the situation if you don't have a contractual provision.
If I could answer Amelia's question.
Yeah, we have a question from Professor Emilia Onyema, a leading voice in international arbitration, and the question is for you, Tariq. Would it be possible for incidents of force hostilities that happen intermittently to be said to be foreseeable, drawing on your example of India-Pakistan intermittent wars?
Now, this may be a trick question for you from Amelia Tariq, so watch out.
It's a difficult one. I think the generic point that I was trying to make was that in the subcontinent, obviously, you've had the three wars, and there's been a lot of hostility between those countries almost on a regular basis, and therefore contractors, companies who have traded in Pakistan or traded in India have taken those factors into account. But when it comes to the question of foreseeability in terms of the legal test, I think my view would be that it'd be very difficult because the unknown or the known, that potentially we know there's hostility between those countries, but as to when they will attack or who will attack first, or it becomes difficult terrain to determine specifically or give a probability, and therefore the test of foreseeability becomes questionable as to how I think it would be. I wouldn't. I would. I think it's a difficult one. I think it would all depend. I couldn't say with certainty that it's foreseeable that India and Pakistan are intending or will have a further war, and therefore that's foreseeable. But there's a potential based upon the history of those two countries, and therefore potentially one could argue that it's potentially foreseeable. But in terms of whether it would satisfy the foreseeability test from a common law perspective, I think it would be a difficult one.
I mean, that sort of makes the point about the difficulty of these cases in an adjudicative process. You just never know. if there was a war every week, or an incident every week, whatever, of any kind, would that make it foreseeable, or every month, or just how's a adjudicator going to conclude about foreseeability? It's, I think, one of the prime reasons why leaving it in the hands of a third party for a decision is risky for the parties.
I think the point that I was trying to illustrate was the importance of having specific force majeure clauses. Uh, uh, I think it's been maybe something that's new within the Middle Eastern context in terms of having explicit clauses to deal with specific issues like war, hostility, or specific points of that nature. Whereas within the, say, subcontinent, it's an issue that has been considered by lawyers and those who have been drafting contracts based upon the previous history of the countries.
There's this article I mentioned before that was talking about, in a business context, about what disruption is or what's foreseeable. And it's interesting, the author uses not what's happening in the Middle East, but what happened with energy in Europe following the Russian invasion of Ukraine in 2022. And he postulates that actually it was quite, if you look back at what was going on in terms of European energy before 2022, its dependence on Russian gas and the supply chains and so forth. I won't go into the detail. You could have foreseen that there was going to be that problem. Is he right? I don't know. But I think it again points out that how uncertain this area is when it comes to determining what is foreseeable or not.
We have also another new question from Amir Al-Qaim. How can mediation offer better outcomes during delay-related disputes? Anyone wish to address this question?
I think, well, it all depends. I don't know. The question talks about delay-related disputes. Yeah, I think it's always good for the parties to keep the communication channel on. I think it's really important. Before we even talk about mediation, we always talk about negotiation between the parties before you bring a third party neutral. So if the parties can engage, actively, positively with each other, even during the delays sometimes are inevitable. So that's why it's always good to kind of engage with the other party. And if you're not able to resolve, that's when you actually involve a third party neutral as a mediator to help out. So it's always important to keep the channel of communication open and keep engaging with the other party. Thank you.
Maybe I can just add a word. Oh, Tarek, you
Yeah,
go
I
ahead.
was just adding that if you are able to resolve matters by way of mediation early, then it'll save you a lot of costs, potentially, save you a lot of time. And ultimately, time is of the essence, and dependent upon companies' financial circumstances, different companies have different needs. Some individuals may have an element where, especially with the pandemic, there was a lot of companies that were almost going through financial difficulty, potential bankruptcies, and therefore either there's the government intervention or with government grants and support, or in the alternative, people may want to, at an early correspondence, offering mediation. And if mediation can resolve matters early on, it saves a lot of time and money.
Also, if I may add that it removes the dispute from strictly attributing fault, and instead it focuses on practical solution. It gives space to address the consequences and preserve the underlying relationship.
And there's also different approaches to mediation. You have the more in terms of the English perspective, you have the facilitative kind of approach where ultimately it's for the parties to resolve the dispute. The mediator is in actual fact acting in a shuttle diplomacy kind of position where going back and forth to trying to bring the parties to some sort of amicable resolution, which can then be formulated into a consent order which can be approved by the courts early on.
Exactly. Thank you, Tariq. Thank you very much for these questions. They really highlight the practical challenges parties are facing today, and the importance of moving beyond purely legal frameworks. So thank you all for this very rich discussion. What clearly emerges is that force majeure is no longer just a legal concept. It has become a strategic tool shaped as much by contractual drafting and commercial realities as by legal doctrine. We have also seen that many disputes today fall into a gray zone where performance is not impossible but deeply disrupted. And it's precisely here in this space that mediation can play a critical role. And rather than focusing solely on rights and liability, mediation would allow parties to reframe the relationship and relocate risks and move forward. So perhaps the key takeaway is this. In time of crisis, the question is not only whether a party is legally excused, but whether a solution can be found that preserves the underlying commercial relationship. So this panel was really very helpful. The session is very rich with practical views and institutional views. If anyone would like to add any remark before closing the session, please go ahead. Barry?
Well, thank you, Dr. Amir. I'll just say that again to you and Dr. Umar, and just really echoing what you just captured. I mean, I think two big lessons emerged from this conversation. One is the limitations of force majeure. We've seen that it is, we've looked at the doctrines and recognized how fundamentally uncertain a doctrine it is. And then we've seen on the other side how mediation can fit in some quite remarkable ways into that gap. And anybody who has taken a standard 40-hour mediation course will have a PowerPoint slide put up on day one that says, here are the bullet points telling you why mediation is a good thing. And it becomes a little bit, it becomes a little bit banal. And yet, in light of our conversation today, you can take every one of those points, and you just mentioned many of them: preserving relationships, flexibility in outcome, managing uncertainty, dealing with legal risks, etc. And they all apply in a quite profound way to this conversation. So I think we've identified a problem, and I think we've identified a solution, and now we just need to work on the practical instantiation of it. So thank you to you and to all of my colleagues.
Thank you so much. Thank you again to our distinguished panelists and to all of you for joining us today. Thank you.
Thank you all. And it was a very interesting discussion and timely. I think, I don't know if this was put together, the topic was put together quickly, but if it was planned in advance, there was a lot of foreseeability at the OICAC, but it's a great initiative and a great topic, an important topic, and tell your friends.
It's indeed very timely. Thank you so much, Omar, for the opportunity. And thank you so much, all of you, for your experience and your insightful point of views and for your presence and attention.
And you did a wonderful job, Amira, of herding cats, literally and figuratively.
Well, I was trying my best.
Sure,
I
sure,
hope you
sure.
are not hating me.
No. Final comments from Professor Tariq?
Thank you for your foresight, Omar, and for organizing this webinar. I think it's very timely, and I think what we've done, more importantly today, is identify a solution to potential claims that may be related to frustration or force majeure, especially in the prevailing position in the region. Thank you.
Thank you very much, Dr. Amira. Thank you so much for expertly moderating the session. And thank you to you all, the panelists, and of course, the participants. The link to the recording of the session will be available to all participants, and I think the team will be posting it on our YouTube channel. So I think you'll have opportunity to kind of watch it again and share and let people learn from it. Once again, I'd like to thank you all and hope to see you next month at our regular monthly webinar in April. Thank you.
Thank you, Omar. Thank you again.
Good day. Good night.